Take Mr. Rowley.
Sorry.
You get a couple of Klondikes.
No, but actually they do have. That's a good
45.
Egyptian musk.
Egyptian musk.
And then there's also some vanilla.
Egyptian musk. The first time I went to a woman wearing Egyptian musk.
And
30.
I mean, I think it's unisex.
Going's black, 20 seconds.
but just up the month it has like 5 for $2. It's really good. It smells really good, and the strawberries smell really fresh. No.
Hi, this is Paula Glory, and this show is called Farther Down the Rabbit Hole because we like to go into topics more deeply. Today I'm joined by a very special guest who's been a guest before, and that's Carl Pearson. He's an attorney, and thank you for joining us, Carl.
Thank you once again. I always enjoy it.
Yeah, we have fun, don't we? I mean, it's nice to outline the problems and then come forward with solutions. Today I would like to talk about copyright, and I know you've had a vast experience for decades in this area. When I was working on some of the 9/11 strategy with your wife, all of a sudden she burst into tears, and it was the memory of how tragic artistic recognition is. So can you tell us a little bit about what copyright is and the theory and then the actual practice?
Right. Copyright basically is the way by which we create slavery and poverty out of our artists.
Wow.
Yeah.
That's quite an opening.
Copyright is for the people that distribute the studios and others that own the finished work, and it prohibits a person from literally making an image and transferring that to someone else without the authority of the owner of the copyright. But the copyright has now taken over the area of law that I used to work in, which I had so much work in that area that I named the area theft of idea law. I just gave it a name, and it's not a real area of law, but that's what I did for many years. Theft of idea is where somebody with a great screenplay idea sends it to a studio in Hollywood or maybe to a New York studio and asks them to consider it and see if we can't do a movie or a television show based on that. And what happens is that before the Copyright Act was changed in about 1956, if I'm not mistaken, a person that had his ideas stolen could bring a lawsuit for theft of idea, various common law bases for doing that, and you could recover. They would settle and you could recover. The problem that the artist has, whether he be an artist in writing lyrics or the notes, the song, or the screenplay, the text of a screenplay, it's really the idea that has the value. It's not the words that are used as much as it's the idea. Somebody gets a fantastic idea that's really a commercially sound idea that people will leap on it.
Right.
There's no protection any longer for that idea, so that when they submit the idea to Hollywood will rip them off and assign numerous writers.
Because there's not like a writers guild where you can
Well, there is a
register.
writers guild.
I mean, for ideas, there's not
Well,
an
the
ideas.
writers guild really should be a bunch of lawyers like me and going into court and defending the interests of the creative person. But
I thought that's what it was. I thought that's why you registered.
We used to be able to do that, but the copyright law was changed, and they said that hereinafter you have to meet the requirements of the copyright laws in order to show infringement. You just can't claim they stole your idea, because the copyright laws do not protect an idea. They only protect the words that are used to express it. So if you have a fantastic idea, really a great commercial idea, and you set it forth in writing and you send it to Hollywood, and they look at the idea and say, oh, that's a fabulous idea, let's make a few changes here and there. So they use different words to express the very same idea, and they get away with stealing your idea with no liability.
Wow.
Because the copyright laws do not protect the person. They have eliminated the right to go into court except under these circumstances. So this is how,
Except under these
I'll
circumstances.
tell you what the circumstances are. This is how you get around it, because I have had an enormous amount of litigation like that. One time my wife and I wanted to sell a video game that she developed to the video game industry. This is years ago. And we went to Chicago. We flew to Chicago and went to a huge ballroom where every video game manufacturer was there. And we went around from one show to another, one display exhibit to another. And we had this huge red case. And I said to the owner of the president of these different video game companies that, you know, it's really amazing, but every kid in 3 or 4 blocks around us keeps coming to my garage all the time, and they're just addicted to this video game that I have in here. Now, there wasn't any video game in there. I mean, we had no working model, but why tell them that? So I told them that we had tremendous addiction. Everyone wanted to have this video game and play it. So I don't know what to do, but we have the design here. But if you don't sign your name and agree to hold it in confidence, then I won't let you see it. So every one of those people signed this thing. And they then became liable if they should ever have used that idea, because I got them to sign an agreement. That's an exception to the copyright law. If you have a contractual relationship and an actual submission made to the company
Wow.
with their consent,
Wow.
then you can obviate the copyright laws that say that you have no
That's
cause of action.
incredible.
Yeah,
So what you're
yeah.
saying, it's better not to show them anything.
Well, of course not.
It just say
Don't
you've
ever.
got all these kids going into the garage and they can't stay away,
Right.
and meanwhile you're not showing them.
The idea of sending it over the transom,
Uh-huh.
the companies have developed a tactic because of me, in the toy and game industry at least, of rejecting them sight unseen. They don't open them up, so they say, and they send them back sight unseen, because with Parker Brothers, I broke their contract. Their contract said that if my client did not sign the form that they wanted him to sign, but I didn't want to argue that because I knew that Parker Brothers wanted him to sign it. My client was pretty sharp, and he avoided it, so he didn't sign it. But I said, okay, Your Honor, look, I will agree that he signed it, because in effect my client knew, and therefore we're not going to claim that he didn't sign that agreement. But they defrauded him into signing the agreement, and that was the issue that was presented to the jury. And the jury held fraud, and they gave us the judgment of the royalties for that game that had been submitted over a 20-year period to Parker Brothers with a written consent. But I broke that consent by having fraud. I allege fraud, and that
Right.
written agreement was gotten around.
Right.
So what they've done meanwhile is they've changed the way in which you can submit games in the toy and game industry. You have to go through an agent. You can't do it directly. Why?
Because I hate to
Because
think
the
of it.
agents are not going to turn on the people that give them money. And therefore the artist who finds that his agent gave the idea to a studio is not going to have the agent cooperating and giving any evidence, so that the studio is protected by the agent instead. They won't deal direct because of people like me that will go to bat for an artist.
Wow.
They insist that you go through an agent who has enough sales to that company where he will worry about losing his income.
Sure.
So that's how they countered my...
So it's like getting worse.
Yeah, it is getting worse. And the enactment of the Copyright Act with all the amendments...
Which year? The
I think it was
Copyright Act?
1958. It might have been 1960 or something. But it's been...
nothing's changed since then.
They took out the right to sue for stealing your idea unless you have plus something more than just copyright infringement. You have to either have copyright infringement, which you never get, because it's so easy to change it. They have writers,
Yeah, right.
10 and 20 writers, change the words that are used to express your idea.
But what if they get bolder and bolder, so that you see them trolling at Hunter College? Because this is what it just came to my attention. I was rolling the camera and it came up that he had a screenplay taken. So I went out and I took a look again. It was Gangs of New York, and I I could see his point. He said it was the story. How about a story? Is a story an idea?
Well,
and
you
the
know,
scenes, it was almost shameless, and it's
interestingly enough,
registered.
If somebody is a participant in the creation of a work, and if they don't have a written contract with that person, the one who helped to create a work has a copyright interest of an equal amount with the others.
You mean the teacher, the professor?
Well, here's what happened with a major artist that used to open for Elvis, a friend of mine. And he wrote a song.
Elvis Presley?
Yeah. He wrote a song that became popular, and a friend of his had helped him in one respect. He suggested that the word white be added to the song instead of tuxedo, that it be called White Tuxedo. And as a result of adding that word white, the guy became an interested copyright owner to the extent of 50%.
Wow.
Yeah.
Wow.
Any contribution, you got to be careful when you're an artist here, because if others help contribute to your work, and if you don't have an agreement, then the courts aren't going to divide it up. It's equal, equal share. So anyone in the area of creation has to be very careful
Well, what
here.
would a student do? Here you are in a class, and you're reading it to each other, and you're learning, and then
there's
you start
a
to
copyright
see.
interest, even though it's not. It's called a common law copyright. You don't have to file it or register it, and certainly there was a copyright interest there. But the problem is that they took the idea and not the literal wording. Undoubtedly, they don't take the wording.
Actually, a lot of the scenes
Well,
are the same.
if
you know,
the scenes are the same, the scenes may be scène faire, which means scenes that will be made anytime a movie like this is made. You can expect to have people walking on a sidewalk, getting in and out of a car, going to a hospital. These are scène faire, scenes faire that you can expect, and there's no copyright credit when somebody steals a scene faire. They have doctrines that force you to have something novel to be protected.
Right. You know, it's interesting. If you think about civilization, you step back and look at this comprehensively. That which has energy to it, Shakti, you know, to the original divine connection, that's what you appreciate the artist for. You think of copying and stealing and imitating as something that is very diluted. You're like less connected to the artistic vibrancy, and it seems like our system is fostering, rewarding more of the conniving, and when you connive so much, if that's your art and conniving, it ceases to open the hearts or attract the audiences that you're trying to attract. So you're almost obliged to steal from people who aren't participating in this game.
Let me tell you what one studio president told his number two, as related to me by that number two. We are never going to pay for a submitted idea. Never. Steal the idea. Don't worry about it. Never, never, never pay for a submitted idea.
Now,
a major studio.
Now, is that the art of the major studio? Is that the art of the deal?
What is the art of a billionaire but to make money the way they know how to do? They don't give away money. If they can get away with stealing, is it stealing?
I can see
it
that.
may be morally wrong, but is it stealing if the law can't do anything about it?
Is it like a thrill to do that?
Is it what?
Is it like a thrill to pay nothing?
No, it's just why
like
why
rich
give
people
away?
Being cheap?
Why look, the studio is $1 billion enterprise, and they are the ones who make a film. That's a little screenplay writer in Brooklyn hammering away at his trade and submitting this idea to a multi-billion-dollar studio. Without that studio and its personnel, its distribution, its techniques, the way they steal from everyone, that little writer would never get a cent. So that it's really a little bit outlandish to think that the writer with a little idea is going to get a $100 million payoff. On the other hand, the studio doesn't even give them really anything. So it's but there's a technique that should be done, and this is a way to beat them at their game. This is what I developed. Never submit over the transom unsolicited.
What's transom?
Transom is where it comes in over the transom of the door where they never solicit it. This is mail thrown in by the mailman and they didn't expect it. Over the transom. That's the phrase that's used.
I see.
So don't submit over the transom. Call up and say to somebody at a place, or just drop in and just drop in to somebody that you know at that at the book company, the publisher, and just drop in and say, oh, I've got really a fantastic work here, and I'd like you to take a look at it. And then this bypasses the note that's in the mailroom saying you must return all these things. You try to go to the people in the organization, drop it on their desk, and then send an email saying, I thank you for looking at this thing, let me know, et cetera, et cetera. That's all you need. If they steal it, come to me and we'll have a good lawsuit.
No, say that again?
Don't mail it unsolicited.
Okay, don't mail it unsolicited.
Drop it on the desk of somebody that you either call, you have an appointment, do something to bring it over to them, and you break through their defense. Their defense is a mailroom notice saying, do not accept any ideas, any submissions at all, return them unopened. That's the defense that they have to my lawsuits.
Right.
So the way of
say, "We never got
bypassing that is to go in there, into the building, or call up and make an appointment, and then when you get there, drop it on the desk and say, and talk about the addiction of all those people, et cetera. And they'll look at it, and if they like it and use it, you're home free, you're going to make a lot of money. But you can't have it unsolicited.
How do you make a lot of money?
By suing. If
If
they use your
the
idea, sure.
How much do you get for an idea? I
Well,
don't even know what
you
ideas
could get
are
millions
worth.
of dollars because it's a part of the gross revenues. And,
Really?
Yeah.
So it's
It really should be in relation to what the value is. What would they would give a writer, they would give somebody a 5% royalty. I mean, you would use an expert witness to try to show.
So it is kind of
that,
recognized that ideas are worth something, right?
They are,
they
but
haven't
only
stamped that out.
if you submit them properly. If you submit them over the transom, they're not worth anything.
I understand
Yeah.
that, but you're talking as a lawyer. I'm talking a little bit differently. When I say an idea is worth something, it isn't all hype and promotion and publicity and and PR. At the end of the day, there is such a thing as content, and that's what this is based on. 5%.
Well, a royalty on a game might well be 10% of the gross price. A royalty on a book is 5, 10, and 15.
Because you're saying
upon,
without this idea it wouldn't have happened.
Yeah.
But of course you can have ideas that without support nothing's going to happen either. So you can see how to have the big Hollywood machinery is important.
If you have a fantastic idea for Dark Rider or Knight Rider or something like Dark Knight or whatever, I mean, it's worth money. But if you just submit it and don't do it the right way, you get nothing.
Yeah, no, I
But
see.
if you have a great idea for a series or for anything like that, make sure you get it to somebody and that you know who it is. You write a letter confirming it, and then if they use your idea, you have a basis for a lawsuit.
Right. Now, you're a very rare, sterling kind of person who is really thinking about people all of the time, all of the problems that you see, and you come up with so many wonderful solutions. But what do you think is the solution to this situation? How do we get a more artistic, creative, vibrant, inspired, less depressed, happy, joyful society as a result of the artists just having their fair share?
I think we're going to have to use alternative media, including public access, including email. We've got to use blogs, websites. We have to develop traffic using Google's AdWords and using...
That's why you're suing Google,
I'm
right?
suing Google for monopolization of the search advertising market. I'm the plaintiff against Google.
Let's talk about that.
Okay. Google, I was running for Attorney General, and I wanted to develop my own New York Times. I felt that if I had...
Attorney General for the state.
For New York State. So I felt that if I could develop a mailing list of 1 million people, then I would have my own New York Times. I could then mail a newsletter every week and describe in that newsletter, well done, what people I think should know. And in effect, if you were the owner of the New York Times, could you run for mayor?
Yeah, I bet you
Okay,
could.
if I had a 1 million subscription base on a weekly newsletter that I sent out for free, that's like owning the New York Times. So I looked at Google and saw that Google was allowing people who use the unwanted words to get the lowest price per click of 1 cent. So if I could induce people to click on my ads, I could convert them into an email at a penny a click. That's $10,000 for 1 million names. Within 1 week after I started that, and eBay, by the way, was being charged half a cent a click for the same words. I chose unwanted words like mustache, jelly bean, shiced head. I mean, some things that people wouldn't want. because that way I wouldn't have any
Then how would
competition.
they click?
Well, because I would say, are you tired of having a shystead for your attorney general? Vote for me, and I'll show you why. Then they would click onto my website, and I would get a
that's
name.
so funny.
So at a penny a click.
So
1 week
clever.
after, the son of a guns increased my price and said that we're not going to allow you to run any more ads unless you agree to pay 50 cents a click. Overnight, 50 cents a click. No human being, and eBay is still paying half a cent a click for the same words. Half a cent a click. And I have to pay 100 times what eBay has to pay. So I brought suit monopolization against Google.
Wow.
And they selected their judge. They know how to select a judge. They force anyone that sues Google for AdWords to bring the suit in Santa Clara County, California,
Did you
which
go
is
there?
San Jose. I'm out there now. There's only 3 judges instead of the 670 federal judges in the country. There's only 3 in San Jose, and only 1 is on an antitrust case, and my case goes to the 1. So they select their judge. And I complained to the FTC. I wrote out a formal complaint to the
FTC, Federal
Trade Commission. I said, look, I know that formal complaints aren't allowed, but I'm filing one anyway just to alert you to what one of the top corporations in the world is doing. They're selecting their own federal judge in antitrust cases. I think
How did
that's
they
improper.
select the judge?
They do it because they forced me into filing a suit in Santa Clara County. There's
Okay.
only 3 judges. There's 657
How
other
can they
federal.
decide
They do
which-
it. That's what they do.
So in other words, if your cousin owned Google and you were a judge,
Well, they have
then you
3
say
judges there.
Then you say bring it to
There's
this
3
my
judges
county.
there.
Why Santa Clara? Why not in Kansas? Why not
Because
in New York?
even in Ireland, they have to go to Santa Clara County.
Why? Who
because
decided
Google said that. It's called a click wrap agreement. When you agree to become an advertiser on, it's a
I
click
see.
wrap.
Because they're a private organization.
Yes.
Say, okay, go
Right.
somewhere else besides Google.
Right.
But how
Yeah,
can
go
you do
somewhere
that now?
else. There's no one else.
Now, you're-
MSN, Microsoft's MSN can't cut it. Yahoo is losing ground, and they
Right.
are trying to reach an agreement with Google to use Google in order to continue with marketing. They're going to license Google instead of using Yahoo. MSN wanted to buy Yahoo and put them together, but if you have one loser joining with another loser, how do you combine 2 losers and compete with Google? Google is by far the best corporation ever. They have a monopoly on information, for Christ's sakes. Every
Right.
single
Right.
field in the world is covered by Google.
Right.
And they're expanding dramatically, and I'm the
Right.
only one doing anything about it, which I think is an outrage.
Oh, I know.
Why me? I mean, why not you? I mean, can't anyone else do it? Why am I stuck with having to do this? You know? That's
Okay,
ridiculous.
but you-
Every single
Right.
field in the world is covered by Google,
Right.
and they're expanding dramatically, and I'm the
Right.
only one doing anything about it, which I think is an outrage.
Oh, I know.
Why me? I mean, why not you? Every single
Right.
field in the world is covered by Google,
Right.
and they're expanding dramatically, and I'm the
Right.
only one doing anything about it, which I think is an outrage.
Oh, I know.
Why me? I mean, why not you? I mean, can't anyone else do it? Why am I stuck with having to do this? You know? That's
Okay,
ridiculous. But
you-
I'm the plaintiff in the
you
lawsuit.
Did it, but you did it, and you said you caught them with their pants down.
Well, here's
That's
what
because
happened.
65 corporations.
Here's what
okay.
happened. That in America, if you have a monopoly on a product or service that you created yourself, you're allowed to charge anything you want. But that assumes in-house development. If, on the other hand, you go to 65 companies and say, give me your technology, and you put it together and you call it AdWords, that's not an in-house developed monopoly. That's a illegally acquired monopoly through illegal combination, conspiracy, and contract and restraint of trade, and for attempted and actual monopolization. And you can break them up. Or, better yet, what I'm asking for is to force Google to charge everyone the 1 cent a click, go back to their pre-monopolization rates, and eliminate the effect of the monopoly by charging a penny a click until you eliminate the monopoly. So that's what I'm asking the court to do out of the Ninth Circuit.
Now, you told me when discovery comes, you're going to need some help, right?
Yes.
Now, to explain what that is, discovery,
Well,
so
I'd
we can
like
get
to
the
know.
help.
I'd like
All
to know
those out
other
there
people,
who should be.
other people who have been overcharged by AdWords, and they're being overcharged so outrageously that you no longer can make a profit. Imagine if you're trying to sell a hot dog, and Google is demanding that every click is 50 cents. You can't make it. eBay is paying a half a cent a click. A half a cent a click.
So eBay
for
and
each
Google?
lead. If you're, the greatest thing about AdWords and the concept of search advertising is that the people that are looking for an elephant are right there putting the word elephant in the computer at the moment that your ad appears before them. You're selling elephants and the person is searching for elephants and your ad goes right there, and for a penny or a nickel you get a goddamn lead on selling an elephant for $20,000 or a jumbo jet.
Mm-hmm.
For 5 cents you get a lead to sell an airplane or something like that. But for a hot dog, if you're selling a hot dog, how can you pay 50 cents a click? A half a cent a click may be too much. So Google is destroying free enterprise in America and subsidizing the monopoly.
What about a Public Utilities Commission? When we brought cellular telephone service to Kentucky, we were obliged to go before the Federal Utilities Commission to make sure that we
they
had
have
an
to be a
800
regular.
number.
They're not yet a public utility, but maybe they will. A statute might say, and that maybe they should. They are a public utility. They are the world's library now.
Right.
Instead of, they are the Library of Congress, and they're even putting on whatever is deposited in the Library of Congress. Google is now trying to put on its website. Whatever is in the private sectors of so many universities, they're trying to put on. They're trying to put blood types on for people, DNA code. They're trying to put everything that's information in the whole world on Google, and they will succeed. But it's a monopoly. No one else can ever duplicate that. It's a monopoly. But just accept it, and they ought to be regulated. They shouldn't be able to charge discriminatory prices. What they charge for AOL or for MySpace or for YouTube, they ought to be charging me the same rate. I ought to have a right to monetize my websites at the same rate that the big guys do. Otherwise, I can't compete with them.
I understand what you're saying. I still want to throw this over to Robert Ashford to see what the binary model would have to say about that, because you usually think of regulation as a little dangerous too, because then you can own the regulators. How can you ensure that the greatest majority of people will be served?
I've got an answer.
Okay.
There are 40,000 towns, villages, municipalities.
Oh, right.
That's it. 40,000 people like me as town attorney generals.
Right.
Enforcing the law. You don't buy that many people off.
Okay, explain city attorney general.
Every town and village, city in the country should have a town attorney general who would enforce the rights of the people at public expense, not the people's expense, not the individual getting help, but the government. Taxpayer money ought to enforce our rights. And if we had that, you're going to have 40,000 people like me seeking to benefit the public by doing the right thing and enforcing law. But as it is now, we don't have anyone like me, unfortunately, and I don't even have me because I can't do all this stuff.
Right.
And the government isn't doing it.
Is that how you got interested in 9/11? Because you saw a big abuse against people, and you always had this in the back of your mind, the solution,
No,
city attorney general?
What happened there, we had a nationwide conversation with about 20 people about 9/11, sort of a steering committee, nationwide, and one of them from Washington said, that in New York City you have a right to a ballot initiative. I said, I never heard of that.
Oh, really?
I said, wow, let me look into it. I said, that's a great idea.
I know ballot initiative, but you always knew about city attorney general. See, that seems to be something
it only came after the ballot initiative. When I learned from the guy in Washington that we had the right to a ballot initiative in New York City,
wow,
that's where I leaped onto it.
Well, Carl, we're running out of time again. It's always so... It's so heartening to talk to you. I always feel so happy after I work with you, and then in the editing I think things through, or I things that I didn't catch the first time. So I'm going to be posting this on YouTube, and I encourage all of you to, play it again and again. 911realinvestigation.org. 911realinvestigation.org. Any New York citizen in the state of New York can put a signature on and really set into motion something
Any
that
New York City resident,
a New York City resident.
resident voter.
Okay, because it's a city attorney general, but you could set them up for all
Yeah,
over,
yes.
even all over the country,
Absolutely,
because the
yeah.
implications of 9/11 are all over.
Yeah.
And thank you for being out there and putting attention on things that grow as a result of the attention.
Good, thank you.